See, since the matter is sub judice, I'd like to be very, very reserved on this particular issue. I don't know what the outcome could be. However, there are different kinds of petitions that have been filed before the Supreme Court. One petition challenges the amendment of Article 370 itself. I think another petition effectively challenges the bifurcation of the state or the trifurcation of the state and creation of union territories without any legislature, okay, or legislative assembly. And another petition effectively challenges what they called the lockdown in terms of cessation of mobile communication and telephone communication. So I will focus primarily on the first two petitions. The argument that they have raised is when there is president rule, there is effectively nobody to speak on behalf of the people of Kashmir to express their opinion or position with respect to the central government's move on amending Article 370. So therefore, according to them, this is against the express provision of Article 370 because there had to be some amount of consultation and some degree of consent that was needed for the actions that the government has taken. Unfortunately for them, the language of Article 370 itself is crystal clear that the provision of Article 370 will apply regardless of what exists anywhere else in any part of the Constitution, which means even if there is an emergency, the power of the president to actually take action with respect to 370 and 35A was still available. Okay. The most important thing is, as far as Article 370 itself is concerned, there are two different keys to that particular mystery. One key is under Article 370 subclause 3. The other key was under Article 370 clause 1 subclause D. Article 370 subclause 3 is a situation where 370 could have been removed from the Constitution before the completion of proceedings in the Constituent Assembly of Jammu and Kashmir, that is before 1956. That means if Kashmir Assembly had decided that we don't need an Article 370, then before the Constitution of Kashmir came into being, they could have decided that, and therefore the entire issue could have been addressed. But today there is no Constituent Assembly of Jammu and Kashmir, right? Therefore that option is no more available. The only other option is to use 371D, which is presidential order, which was used to bring in 35A, has been used to take back 35A. So they've effectively said, think of the president's hand as abhayastam of some deity. Jo de sakta hai, wo le sakta hai. That's all. That is effectively the position that they've effectively gone with. And most importantly, what they also did was through Article 367, the reference to Constituent Assembly in Article 373 was replaced to Legislative Assembly. Okay. So the government has actually thought this entire thing through. I'm not saying that therefore it is constitutionally invincible. You never know how the Supreme Court may interpret it tomorrow. Maybe they agree with the outcome, they disagree with the process. All that can happen. But I think surely the Supreme Court will be cognizant of the fact that any adverse order it gives with respect to this move of the government will result in strengthening the position of an extremely mischievous party, which is Pakistan, and another interested party, which is China. Okay, so I'm sure that the Supreme Court will take all of these into account because the Supreme Court does not live in a bubble. It understands what is at stake. And it's an extremely wise institution, according to me, which will know for a fact that even if it has, let's say, some creases on its forehead with respect to procedural issues, at the end of the day, कश्मीर को किसी न किसी दिन भारत का अंग बनना ही था, जो बन चुका था. Whatever bridges existed, difficult bridges have been removed. That's it.